Welcome to your ultimate guide to the world of intellectual property law. Whether you are an inventor, entrepreneur, or simply curious about how ideas become protected assets, this podcast is for you. Each episode, Spoor and Fisher partner and legal professor, Professor John McKnight, will explore the intricacies of IP and delve into specific disciplines to guide you through patents, trademarks, copyright, and more.
So let's talk about patents. A good definition of a patent is that it's an agreement between an inventor and the government of a country in which the inventor agrees to publish his or her invention, and in return, the government agrees to give the inventor exclusivity on the use of the invention for a limited period of time. Now, there's a lot in that definition. The first thing we have to have a look at is that it's an agreement between an inventor and the government of a country. So if you want patent protection in the US, then you have to engage with the US authorities. If you want patent protection in Australia, you have to engage with the Australian authorities. And so it is for South Africa, etc., etc. There are a couple of conventions and the like which make it easier to create regional protection. And I'm thinking here particularly of the European Patent Convention, which allows you to have a single application process which ultimately result in a bundle of national rights. And we are now moving to what's called the Unitary Patent Convention, the UPC, which allows you a single right across Europe. But as a general rule, if you want a patent in a country, you have to engage with that country's patent office and abide by that country's laws. And most importantly, you have to instruct patent attorneys in that country, right? So that's where it gets expensive, because we've got a patent application in the United States, and we are instructing attorneys who are charging $650, $750 an hour. We're paying in rands. The same is happening in Australia, in Japan, in Europe, where we're paying in Aussie dollars, we're paying in yen, we're paying in euros, and always the base currency is rand. So it just gets more and more expensive. So it's not for the faint-hearted. Global patent strategies are expensive, fragmented, and a lot of thought needs to go into their appropriate construction. And that's all because a patent is an agreement between an inventor and a government of that country. Right, okay. So how does it work? The government basically says we need to improve the lot of our citizens, and we do that by solving problems which afflict society. As a government, we're too busy running the country, so we're going to incentivize the population to solve their own problems. And how do we do that? We say, if somebody solves a problem in a manner that is completely novel, which is to say it has never been described before in the history of humanity, and it results in a technical advantage, now we're talking. That's what I'm talking about in terms of patent protection. And what happens is that I will give the person who comes up with that solution, who comes up with that invention, I will give them a 20-year monopoly, so that they are the only ones who can practice that invention, and in so doing, they can enjoy the fruit of their labors. Okay, so that's how it works. It's a quid pro quo. It's an incentivization. So, but like with almost all deals, terms and conditions apply, and those are: the inventor must agree to publish his or her invention. Okay, which means that's why you have a patent specification which sets out the invention. It exemplifies the invention. It explains exactly how it works. And it ends with the claims defining the monopoly, what others are not allowed to do. And these documents are publicly available, all right? That's how we get to the name patent. Patent is actually a Latin word meaning open or obvious. So everybody can go down to the patent offices. Well, they don't really go down to the patent offices these days. They hit the online databases, and you can read any and every granted patent in any country around the world. They are all open to public inspection. And that's for a number of reasons. The first is people must understand, they must know what they're not allowed to do, right? And then secondly, when the patent expires, or as I mentioned earlier, if the annual renewal fees are not paid and it lapses, then people must have a document which instructs them how to practice the invention, right? How to put the invention into use. And that's the purpose of a patent specification, is to teach others how to practice the invention, and during the life of the patent to explain exactly what they're not allowed to do. Okay, so in return for this publication, the government agrees to give the inventor exclusivity on the use of the invention for a limited time, and it's normally 20 years. Now, in South Africa, for example, that 20 years is done and dusted. It's a hard stop. You can't get any extensions. But in some countries around the world, most notably Europe, you can get what's called a supplementary protection certificate, which allows you to extend the life of a patent for a couple of years, but it's usually much narrower in scope than what the original patent claimed. And this would typically be drawn to pharmaceuticals, where you have to file your patent application right at the beginning of the life cycle of the pharmaceutical, way before you begin clinical trials, etc., etc. And given that it can take anything from between 8 and 15 years to bring a pharmaceutical successfully to market, and the chances are really stacked against you that that's even going to happen in the first place, to the extent that you do get your pharmaceutical licensed and you can begin making and selling it in these countries, you've only got about 5 years of your patent left. Now, you've not only got to recover all of the costs that went into this particular molecule's research and regulation and clinical trials, but you also have to cover the costs of all the other ones that didn't make it. So it's a huge mountain of debt that you have to address, and you only have 5 years to do it. So what do? You jack up the price of your successful candidate drug, right? And that's why they tend to be so expensive. So in an effort to bring down the costs of new drugs, they allow patent holders an extra 5 years of exclusivity to recover these costs. But that extra 5 years, which is covered in, as I said, the SPC, the Supplementary Protection Certificate, that is limited to that particular molecule that got regulatory approval and is being marketed. So all the other molecules, they become public domain, but the one that's been made and sold, that gets an extra 5 years. And it's just to spread the enormous costs of bringing a drug to market over 10 years as opposed to 5 years. So that's the idea behind the use of an invention for a limited time. When you do get your patent application granted, a certificate is usually awarded to the patentee to conclude the agreement, and this is called the letters patent, which means letters which are open. And of course, like I said earlier, anybody can go and read those. So what can be protected by a patent? An invention can be anything which does not fall within the exclusions listed in the Act. And so there could be a device like the Leatherman knife, pen knife, pocket knife, multi-tool, whatever they're called. It can be a method of making things. It can be a machine. It can be a process. It can be a composition of matter. So it can be a molecule. It can be a mixture of things. So if you have a formula, it can be a cleaning formula. It can be a medical formulation. Anything really, a mixture of known ingredients in a novel mixture in a novel concentration. All of these things can be protected by patent. So in short, anything that solves a problem in a new and a non-obvious manner is protected by patent. So, like I said earlier, there are some terms and conditions which apply to this deal, which are you're going to enter into with the government of every country. And in order to be patentable, an invention must be novel, it must be inventive, it must be capable of being used in trade, industry, and agriculture, and it must be suitable subject matter. So if we just look at novelty, like I mentioned earlier, the publication must never have been made public in any way, for example, by oral disclosure, use, trial, printed in any publication, in any language. So a publication in Mandarin a month before you file for your patent application, if it describes the same thing, will be enough to invalidate your patent application because your patent can no longer be considered novel. So any such being made available to the public anywhere in the world before the date on which an application for a patent is filed is novelty destroying. So if you just think about it, that is an extremely high barrier of entry into the world of patentability. You must be the first person in the history of humanity to think about this problem and to solve it in the manner that you suggest. It's quite special to get a patent. It's really not to be underestimated. Now, we get to the next one, inventive step. Oh, my word. So the typical idea behind inventive step is, would someone with a good knowledge and experience of the subject, that is to say, a person skilled in the art, think that the invention was obvious when comparing it with what was already known, which is, like I said, the prior art. Oh, how do you go about solving that? So let's just say, for example, let's stray into the world of fiction for a moment and pretend that we live in a world where there are only red bicycles. We know bicycles, and they're cool, and lots of people own them, but the only bicycle known to man is red. You come along and you say, you know what? I'm going to take my red bicycle, I'm going to paint it green. Okay? And I'm going to apply for a patent for that. So you send it off to the patents office and you say in your claim, I claim a bicycle which is green. Okay. So the patent office is going to have a look through the prior art and come back to you and grudgingly admit that, yeah, they can find no record of a green bicycle. So it is novel in the sense that it hasn't been described before. But then they'll come back and they'll have a go on inventor step and they will say, yeah, but it's a bicycle and the only difference is the color. So that's a trivial difference. There's no technical advantage or improvement associated with painting your bicycle green. So I'm going to deny your application for a patent because it lacks inventor step. It is obvious over what was known. Green paint was known, green houses are known, so it would be obvious to take a bicycle and paint it green. And that's when patent attorneys come to the fore, because we say, actually, hold on a minute. There are technical advantages which come from painting a bicycle green. Okay? The first is, so we did a trial. We went to the Isle of Man and we put half of the bicycles on the island were red and the other half were green. And then we went back after 6 months to find out what was going on. And what did we find? We found that a much higher proportion of red bicycles were stolen rather than green bicycles. Now, why is that? And we think it's because red bicycles can easily be seen. If you lean them against a hedge or bush or on the lawn, you can see that there's a bicycle there, and that gives rise to opportunistic theft. Green bicycles blend in to hedges. They blend into bushes. And if you leave it on the lawn, you have to look twice before you see it. So they don't get stolen as often. And that's technical advantage associated. That was non-predictable. We didn't know that was going to happen. But there is an invention there. If you paint your bicycle green, it is less likely to be stolen. And that's how we work with inventor step. So we prove technical advantages associated with the point of difference. With the point of novelty, if we can prove that there is something better, an improvement that wasn't immediately predictable, then we're on line for a patent. So that's how inventor step works. And then finally, use. It's got to be capable of use, trade, industry, and agriculture, which means that it must be capable of being used or has some practical application. So what does that mean? It's designed to exclude scientific theories, etc., etc. So, for example, if a inventor came to you and said, hey, I've got a great theory of how water molecules pack together, and it explains how different molecules dissolve in water. So if you try to draft your patent application for a method of water molecules to pack together, that would be denied because that's not capable of being used in trade, industry, or agriculture. But if you framed your patent application of a method of predicting the solubility of a molecule and then using the theory to do that, that has practical application, that has use, and that is patentable. And then finally, it's got to be suitable subject matter. So this is an interesting aspect of patent law. The Act defines things that simply cannot be patented, right? And you'll be surprised how broad-minded the powers that be that drafted the Patents Act are. They're not, we're all adults here. So, there are a remarkable number of mechanical patents and the like, which make your eyebrows rise, but they're not really focused on that aspect. It's things that are not in the interests of society as a whole that they're looking to exclude from patentability. So that would be instruments of torture. They're definitely not patentable. Methods of making a letter bomb. Nobody needs to know how to make an improved letter bomb, and things like that. And then, of course, things which go against well-known laws of nature. So that would be most often perpetual motion machines and things like that. They're not patentable. They won't even let you out of the blocks. And you'll be surprised how many inventors present themselves claiming to have invented a perpetual motion machine. But of course, you just ask them for a quick demonstration, and it's not long before that's that. So anyway, a perpetual motion machine is denied patentability from the get-go because it falls under one of the things that are specifically excluded in terms of the Act. Okay, so patents, grant and effect. The term of a patent is generally 20 years from the date of filing. As I explained earlier, there are some exceptions to that rule. And what happens is a patent is not a positive right. Okay, so if you do invent a new drug, you don't have the right to sell it. That right only comes from the Medicines Control Council and other regulatory authorities, which you have to satisfy them that it's safe, etc., before you can make and sell it. All that a patent gives you is the right to exclude others from performing the acts of making, using, exercising, disposing of, which is another word for selling, offering to dispose of, which is another word for advertising, importing or keeping the invention. Those are the acts which are specifically excluded. So as a patentee, as the holder of a patent, you have the right to exclude others from making the invention, from selling the invention, from importing the invention, and so on. So that's basically how the practical effect of a patent. So like we mentioned earlier, patents are territorial. To stop someone making use of your invention in any particular country, you must obtain a patent in that country. There is no such thing as a worldwide patent, but two major processes exist for applying for patents in several countries at the same time, and we will explore each of these in more detail. There's the international route through what's known as the Patent Cooperation Treaty, and then there is the European route, which is known as the European Patent Convention, or the EPC. The international route allows you to go into countries and take your application forward in that country, whereas the EPC results in national patents in each of the contracting states to the European Patent Convention. The thing about a patent application is that once you file for your patent, it starts the clock on a number of timelines. So if we just look at getting a patent in South Africa, how we normally kick it off is, the inventor comes to see the patent attorney, explains his invention. The patent attorney sits down and puts together a provisional application, which just sets out the idea, puts some kind of the best claims that they can figure out at that point in time, some examples, and they just sort of codify the work that has been done to get to that point. And they file it at the South African Patent Office, and that is known as the South African Provisional. And what that does is that starts the clock going, because within 12 months of filing your provisional, you must file what's called your complete application. Now, provisional doesn't have to have a set of claims, a complete does. And a complete's got to have everything. It's got to show how the person applying for the patent has derived title. You've got to make all your declarations about how you haven't filed for any other patents, that you don't infringe the acts of the National Environmental Biodiversity Act, all these good things. So it's a complete application, and so you use that 12-month period to carry on working on the invention, to iterate the invention, so that by the time 12 months have elapsed and it's time to file your complete, you've got the best application that you can. It's got more examples. You've figured out how things work. You've figured out what doesn't work, what does work, and you've included all of that. Now, in South Africa, your complete application will just proceed to grant. It's not examined by anybody. It's just examined formally. Have you paid the fee? Do you have all your powers of attorney, etc., etc.? And within a year, 18 months, you can expect to have your South African patent granted. Relatively simple, relatively cost-effective. But if you go the foreign route, there are two ways that you can go. First of all, it starts off with exactly the same footprint. You file your South African your provisional patent in South Africa. That kicks off a 12-month period, exactly the same. And at the point where you would file your South African application, you then file what's called convention applications in all the other countries, like, for example, the European Union, Australia, the United States, Canada, etc. And how it works is, why we call them convention applications, is because there is a convention that most countries are signatory to, and that is the Paris Convention. And what that basically said was, if a member country has a provisional application filed in it, then all the other member countries will recognize that, and they will recognize that priority claim so that when it comes to be filed in their country 12 months later, they will recognize the priority of the first one. Now, why are priorities important? They're important because they set the date by which novelty and inventor step are judged. So if a prior art document is published the day before you file your South African provisional, that counts as prior art against you. If that prior art document is published the day after you file your South African provisional application, then it's meaningless. It's not taken into account because it's first across the line and you got there first. So the convention applications, they all recognize that concept. So your priority date is accorded to all of the applications which are filed in convention countries. And then, of course, you go down the traditional route of examination. So South Africa is unusual in that it is currently a non-examining country. There are plans afoot to make it an examining country, but they have not come to fruition yet. But it's coming. The other countries like Europe, Australia, the US, China, they have armies of examiners. And when your patent application lands on the desk of the patent office, it gets routed to a guy who's skilled in that particular area of technology, that platform. And it comes before him and he says, if he's the bicycle guy, he will know if a green bicycle has ever been applied for. And he will know if your argument holds merit as to why there's a technical advantage associated with a green bicycle as opposed to a red bicycle. And so they are substantively examined in these other countries. There's a lot of back and forth. Letters are exchanged. Arguments are made and accepted or rejected. And so it goes before finally you ultimately get your patent application in those different countries, usually after having dispersed a fair amount of money. One has to be honest about these things. The third and final way that you can get it is by way of what's called the Patent Cooperation Treaty. And what this does, a Patent Cooperation Treaty, again, it's a treaty which has been signed up to by about 130, 140 countries around the world presently. And what it does is instead of filing your complete application at the end of 12 months or the 12-month anniversary of filing your provisional, you actually file with the Patent Cooperation Treaty authorities. And they are a branch of the UN. The World Intellectual Property Organization, they're called. They're based in Europe, and they administer the PCT. And what it basically does is that it gives you another 18 or 19 months, depending on the country, to figure out your invention, to fine-tune your invention a little bit more. And it gives you an idea of not so much to change your patent application. You can't do that after the 12-month anniversary, but you can figure out where it's of interest, in which countries it's going to be of interest. Are there any licensees out there who are interested in it? Are you going to be able to commercialize your invention and take it out there? So you're in a much better position about the strength of your invention. The PCT will also issue a document. They will examine the application, and they will issue a document called the IPRP, which stands for the International Preliminary Report on Patentability. I know it's a bit of a mouthful, but it's a hugely important document because it basically says, yes, this invention, as the guy has claimed it, is novel, is inventive. Each of the member countries should be comfortable in granting it. Or they say, actually, this invention has been anticipated in the following documents. It's not patentable. The applicant needs to go back and revisit his application and make it narrower to make sure that it is patentable. So it gives you a very good idea of patentability. Are you actually going to get a patent granted in the US or China? Of course, even with a good IPRP, there are no guarantees, but it's really helpful for peace of mind. So PCT is a hugely popular option. A lot of people go for it. And because it buys you this 18 months and it gives you a good idea of market reception and whether you can expect patent protection at all.
You are a leader, a visionary. You embrace technology to develop cutting-edge solutions. You are original and innovative. You imagine. Trailblazing is often a lonely path, but we see the extraordinary in what you do. When it comes to understanding and protecting your intellectual property, your journey is our journey. Visit our website at spoor.com and discover how we can protect what is uniquely yours. Spoor & Fisher. Create it. Own it.